when it doesn't have to be joint of parties. Joint of parties is when you want to go bring someone. Okay. So the answer to your question is yes.
What is confusing me is in the first class that we had, you told us that if you see two suits that have a common question of law or facts, the two suits should be joined together. And now
they will be joined together. They will be joined together. Let me explain to you that concept. Now, we have co-plaintiffs. I mean, if you talk about joinder, okay, and you are, and I've said joinder is whereby you are joining, you're joining someone in a suit. You can bring that person as a co-plaintiff or as a co-defendant. Now, how do you bring them as a defendant or as a plaintiff? When there is a common question of law or there's a common question of fact. Are you together? It's a common question of law or it's a common question of fact. You getting what I'm saying? Now you can decide to join them together, to join. Okay, you can decide to join them together. So when you join somebody as a plaintiff, then if you're the plaintiff, that person becomes your co-plaintiff. Or if you bring somebody as a defendant, if there was a defendant already, then that person becomes a co-defendant to that defendant. Okay, or you don't have to have a joinder. You can from the onset, you can have two people suing together jointly. So yes, when you talk about co-plaintiffs and co-defendants, that is a question of joinder. Okay, joinder is different from test suits. Now, test suits are these people have already filed their matters individually. Okay, they have already filed their matters individually, but because what they're claiming is the same in all the 10 files, we just pick one file to represent all of them. Okay, that is one file. The reason why we don't want to why we pick a test suit is because it will make no sense having hearing dates for each of the 10 files when you can just have one hearing. Okay, so joinder and a test suit, both of them serve one purpose: saving the court's time and making sure that there's no repetition. So that is what you're saying. That is what I want you to understand. So yes, joinder will give you the co-plaintiffs and the co-defendants. At the same time, when you pick when you pick a test suit, then essentially also you're saving the court's time. I don't know whether we are together. So why would you pick the reason why we pick the reason why we pick a test suit is almost the same reason why we have a joinder. Okay, because remember these 10 files, if they'd interacted before, they could have decided to come as one, but they didn't. So even these 10 files, if we go back in time, we could have had them as 10 plaintiffs suing one defendant, and that is joinder of plaintiffs. Okay, but because they've already filed their matters, kila mtu ashaenda peke yake, then the only option that we have is to pick a test suit out of that. Okay, so what the court is telling them that, hey, you guys have just joined yourself together and become 10 plaintiffs versus this defendant. But now that you guys have already filed your matters, we can't throw your matters away. We will just pick one file, and that one file will be tested, and then whatever is found will be put in your files. So the grounds for joinder are the same grounds for picking a test suit. Are you together?
Yes, I'm answered. Thank you.
Okay. Any other question? Any other question? Yes, Jennifer.
I'm not sure if I'm drawing the right parallels with the representative suits, the test suit and the representative. Is it one of the same, or there's a difference?
A test suit is an example of a representative suit. A test suit is not the same as a representative suit. The representative suit is not there's no specific suit called a representative suit. A representative suit is an umbrella term where one person or one file represent others. So it could be a test suit, number one. It could be a class action suit, whereby one person is suing on behalf of a different an entire class. It could be a public interest litigation whereby Okia Mtata will go to court and represent everyone. So that is that instance, those different instances. I've said there's a class action, there's a PIL, and then there's a test suit. All that, the umbrella term is representative suit. I don't know whether you're getting that.
Yeah, thank you.
All right. Any other question? All right. There is no question. So guys, I want us to start again from where we left in the last class. We've been drafting, somebody's having the microphone on, mute your microphone. We've been having discussions on preparation of suits and specifically pleadings. So we have drafted the originating pleadings. We have drafted originating pleading. And in this instance, we have drafted a plaint, we have drafted a petition, we have drafted a statement of claim. At the same time, we have drafted a pleading in response, or the pleadings in response. And I said in the last class that pleadings in response are just the same format. Okay, the same format. If you have a pleading in response, is the same format. Right together. So whether you are drafting, of course, you know the different categories of pleadings in response. You know the different categories of pleadings in response. And number one is, of course, defense, which responds to a plaint, a defense and a counterclaim that responds to a plaint as well, memorandum of response that responds to a statement of claim, and also we have an answer to petition that responds to a petition. Now, drafting them is all the same. The only thing that will change is the caption of the parties, and just a few terminologies here and there. Are you together? So that is the classes that we've been having in the last two classes. We've been able to draft those a few, or generally we've drafted all the pleadings. So in the last class, we were doing a defense. We were doing a defense, and I was explaining to you how you need to prepare a pleading in response. Okay, a pleading in response is a pleading that responds to an originating pleading. And in that, we picked up a defense to be our benchmark. Now, if you look at my screen, this is how we are drafting our defense in the last class. Let me just put it like that. So this is our defense. This is our defense. So let me take that out. What the hell is this? Give me a minute. All right, so all right, thank you. So there we have it. So we said there are various ways of responding to a plaint. If you are preparing your defense, remember that it is a defense. You are defending yourself. What are you defending yourself against? You're defending yourself against the plaint, against the plaint that has been filed against you. So how do you respond to a plaint? You respond to each and every paragraph. So you read each and every paragraph and you confirm whether that information is true or is false. So if it is true, according to what the client is saying, then you'll be saying the defendant admits. So you either admit, you either deny, or you admit and avoid, or deny and avoid or traverse. Okay, so that is the only way you are supposed to respond to or supposed to make your defense. Okay, defendant admits, defendant denies. Okay, defendant denies and further states. Defendant admits but further states. So how it happens in an exam is this. Okay, how it happens in an exam is this. You can see my screen. Somebody is asking whether my screen is visible.
It's visible.
All right. Yes.
I'm saying on my side it's not visible.
You might need
Also
to
not
leave.
visible from my end as well.
You might need to You might need to leave, or I might be the one to take down my screen and to share again. Let me take down my screen and share again and see whether you guys will see it now. I'm bringing it up again right now. So confirm with me if you can see Saina, Waire, Anthony. Yes,
Yeah, it's now visible. Thank you. Yeah.
All right, Sawa. Now, this was the question of preparation of a defense. Now, I was telling you how it happens in an exam, and you need to be very keen. Just be keen. If you're keen enough, you're going to pass this question if at all it is set. Okay. Now, how it happens in an exam is this: you will be given a plate. Okay, you will be given a plate. Are you guys together? You'll be given a plate that is already drafted. Okay, a sample of a plate or some few paragraphs of a plate in the question. Okay. Aside from that, remember that you are representing the defendant. So you're given a plaint and then you're told to prepare a defense. Now, before you are told to prepare defense, you will be given now the statement of your client, who is the defendant. The plaint will contain what the plaintiff is saying, okay? And then the defendant will be also giving you their side of the story. Now, the side of the story of the defendant will come as additional information. You will be told that please or see attached, or you've been shared, you've been given the following, or your client has been served with the following pleading. That is a plaint, okay? And then the question will further tell you that after the client interview with the defendant or with your client, this person and this person, you've or your client has given you the following additional information, okay? Now, what you need to do in that instance, you need to prepare a defense or a defense and a counterclaim, depending, okay? Now, go have your defense, just the caption. The caption is always as per the plaint, okay? And then the statement of defense. So you read paragraph 1 of the plaint the way it is in the question, and then you come and read additional information and ask yourself, has paragraph 1 been contradicted in the additional information? So if your client is not contradicting paragraph 1, you'll be saying the defendant admits paragraph 1 and 2 of the plaint. You read paragraph 2 of the plaint. Maybe paragraph 2 of the plaint is saying that there was a contract between the plaintiff and the defendant. And then you come to the additional information, because the additional information is what your client is telling you. So that is what you're going to put in the defense. So you look at that. Paragraph 2 is saying what? There was a contract. Come to the additional information, okay? Come to the additional information. What are you supposed to do there? So once you come to the additional information, then you read, is your client also agreeing that there was a contract? So you can find in the additional information that your client is not agreeing or agreeing. So if your client is agreeing that there was a contract, but indicates that the contract was not signed or was not dated, then you come and say that the defendant admits paragraph 2 of the plaint, but further states that the contract or the said contract was not signed. You go to paragraph 3 of the plaint and you ask yourself, what is it saying? It is saying that the contract indicated that the defendant was supposed to deliver 30 bags, okay? 30 bags of cement, for instance. Go to the additional information. Is that the same thing that your client told you? So you go read there and you find your client saying, no, it was not 30 bags of cement. It was actually 10 bags, okay? So you'll come and in your defense and write, the defendant denies the contents of paragraph 3 of the plaint and further avers or state that the contract provided for 10 bags instead of 30. Guys, that is a very simple thing. Anybody can do that. If you pick your grandmother from the village and you told them to draft this, they will draft it. It's simple. Drafting a defense is very simple because kazi yako ni ku admit, ku agree, or to state further. rahisi sana. Drafting a defense is not hard because you are just looking at the question, I mean the plaint, and then looking at what your client told you. So what your client told you will either, the examiner will make it clear by giving you that as additional information, or it will be part of the fact pattern, okay? It will be part of the fact pattern. So you'll be given a copy of the plaint, and then you'll be told in the facts that, oh, after this, you visited your client on this date, and then, or your client came to your office, and as you're speaking to your client told you 1, 2, 3, and 4. So that 1, 2, 3, and 4 is supposed to be in the defense. Kathwa, Alex, your video is on. You might want to mute it. Kathwa, Alex, are you there? And your video is on and you're not even in this class. How can I help you, Kathwa? Let me see how I can unmute your video. Some of you are not even in this class. And you're sleeping. And you're smiling. What are you smiling about, Alex? All right. Can you guys hear me? Maybe I think you guys, my audio is delaying. If I call your name, it takes some time for that audio to get back. I mean, to get to you. Can you hear me instantly? Like instantly as I speak?
Yes,
Yes,
we can.
Malia, we can hear you.
Yeah.
Okay, then that means Alex is not here. Alex, can you come back? Come back to this class, please. Huyu mtu anakupea stress hapo, mwambie angoje kwanza. Stress baadaye. All right. So that is how we prepare. We prepare your defense. Defense is very easy. The same applies to your memorandum of response. Memorandum of response is when you're responding to a statement of claim. Memorandum of response is when you're responding to a statement of claim. Are we together? That is a memorandum of response. A memorandum of response. The same way you'll be saying the respondent admits, the respondent denies, the respondent denies but further states. Okay? Because remember, in a statement of claim, in a memorandum of response, we have the claimant and the respondent. Even if it is the petitioner, respondent. The same way, the respondent denies, the respondent admits paragraph this of the petition. The same thing, guys. The same thing. Are we together, guys? So once you admit and so what will guide you in terms of stating further is what the examiner said, what the question says. So if you look at this, you will admit, deny, traverse until the last part. After the last part, you come and say reasons wherefore. Okay? Reasons. It is a pleading. A pleading must have prayers. What are you praying for now? Reasons wherefore the defendant. So this prayer is also very this prayer is also very constant. It's a constant prayer. It could be the defendant. If it is a memorandum of response, it is respondent. If it is a petition, still also the respondent. Okay. Praise for the following remedies against the plaintiff, if it was a plaint, or if it was a statement of claim, claimant. Okay. If it was a petition, it could be petitioner. Petitioner. Okay. What are you praying for? Number one, what is the first obvious prayer that people pray for whenever you are, whenever you're preparing your, these guys are really disturbing me. Guys, join the class in good time. I don't want to keep exiting my screen and going to add you back and in. Okay. So what is the first prayer that everyone will be praying for? Okay. The first prayer is that either the plaint if it was a plaint, okay? If it was a petition, okay? If it was a statement of claim, be dismissed. Okay, that's the first play. You're paying it. They sued you, so you don't want to be sued. Be dismissed. Full stop. That is that. Number two, cost. The cost of the suit. Interest. Interest on maybe on just say interest, and then any other relief. Any other relief that the court may deem just and expedient. So these are the only prayers you're going to have. So if you have a plaint, the plaint be dismissed. If you have a petition, the petition be dismissed. If you have a statement of claim, same thing. And then you pray for cost, and then you pray for interest, and then you pray for, you don't pray for those other remedies, permanent remedies, because you didn't sue. The plaintiff is the one suing for maybe damages, compensation, permanent injunction. This is left for the originating pleading. You, as somebody who is just defending, you want the things to remain the way they were. So how do you do that? Throw away the the plaint, petition, or the statement of claim, and then have the cost of the suit and interest and any other remedy. Full stop. You're done. You proceed and you date. So you can have the dated at Nairobi, this dash of dash 2024. Are you together? That is how you prepare your defense. So up to there, you have a full defense, of course, with drawn and filed by to be served upon and the signature part. So the examiner will give you your full marks from the caption, tick, parties, tick, statement of defense, tick, the response, tick, tick, remedies, tick, dated, tick, signing and drawn and filed by, tick. You have your full marks. Very easy, very simple. Don't be on a rampage to use legalese. You will cry. Don't use legalese. Make it as simple as possible and move. I've told you guys, if you're lucky enough, you will practice law for 100 years. You will. So those things you want to write in this exam, go write them in practice. You'll have all the time and all the papers, you have all the things. So please, for this exam, keep it simple, direct to the point. That is how you prepare your statement of defense. Now, let us now have a counterclaim. Let us now have a counterclaim is only found when you're preparing a plaint. Okay, so we're going to have back our statement of defense and a counterclaim. So there's no independent. There is no independent. Any questions? Ayana, you have a question?
Yes, just a clarification. Maybe what did you, paragraph 2 of the statement of defense, you stated that the defendant admits the contents of paragraph. What did you intend to put there?
No,
and then,
don't cram it like that. Don't cram it like that. Don't cram it. I was just giving a general example. I was not mentioning. Okay. Is that general? I'm just giving a general example and saying if you are given a plaint and you're told to respond to that plaint, there are a lot of things you could say. Okay, there are a lot of things you could say depending on what the plaintiff said. For instance, for an example, if I gave you a plaint right now in an exam and I told you to respond to that plaint, then the first paragraph of the plaint is usually obvious. The description of part admits paragraph 1 and of course paragraph 2 of the plaint. Number 2, if the second paragraph or if the third paragraph of the saying that there was a contract is an example, there was a contract, or if the second paragraph is saying that the driver was driving fast or this person was the one driving this motor vehicle, you go to the additional facts and confirm, is your client admitting this fact that he was driving? So your client can say, no, I was not driving this vehicle. Okay, so the client or your defendant denies paragraph 2 and further states that on that specific day he was sick in the hospital. If paragraph 3 is saying, for instance, okay, if paragraph 3 is saying, for instance, if it is defamation, assuming it's defamation, that the defendant published something on their TikTok page defaming the plaintiff, the defendant can respond by saying, no, I don't even have a TikTok account. Okay, so your response in the defense will depend on what your client has told you, but it is on the lines of admit, deny, admit and traverse, deny and traverse. How do you do that? The defendant denies, full stop. The defendant admits, full stop. The defendant admits but further states. The defendant denies but further states. Okay, so you can deny in totality and have nothing to say, put the plaintiff to strict proof, or you can deny but add something that was not stated by the plaintiff, or you can admit by saying, yes, I slapped him, I admit, but I did not slap him on the neck, I slapped him on the wrist. So you are admitting but further adding something to put context. Are you together? So you can, the only responses you're going to have in that defense is admit, deny, admit but further states, denies but further states. Okay, that is all.
Thank you. Thank you.
So,
yes. Thank
so
you.
just have that at the back of your mind. Tuko sawa? All right, sawa. Now let us look at a counterclaim. Let us look at a defense and a counterclaim. How do you handle a defense and a counterclaim? How do you handle a defense and a counterclaim? Now remember, there is no suit, there's no pleading called counterclaim. A counterclaim cannot. If a counterclaim was to stand on its own, it could be a plaint. It could be a plaint. It cannot stand on its own because if it was to stand on its own, it could have been a plaint. Are you together? It could have been a plaint. So because it is a counterclaim, it must stand with the defense. So you're going to have your caption as a defense and a counterclaim. So what will inform you? What will inform you that this is a defense and a counterclaim? When you read the facts and you realize that your client is also suing, is claiming something. Guys, there are two things. There's denying or responding, and then there's claiming something. So if your client is just denying, accepting, denying, accepting, that is just a defense. But if it gets to the point where your client is also saying that, as a matter of fact, I'm also claiming something from the plaintiff, then that becomes a counterclaim. So if your client is also seeking something, your client also wants something from the plaintiff, then that becomes a counterclaim. So how do you insert a counterclaim in your defense, statement of defense, and counterclaim? That's where you start. And then you start with the defense first. Defense. Once you're done with the defense, let me bring it. Let me remove this and bring this counterclaim back here. All right, so can you see my screen? I hope you can. So you will do your defense. You will do your defense until the last paragraph, okay? Do your defense until the last paragraph. Once you handle all paragraphs of the plaint, and then you're going to write counterclaim. Just write counterclaim and underline. You don't have to go back and copy the entire, parties. No, don't copy parties. Don't copy parties. That will waste your time. Just write counterclaim and then write by way of counterclaim. By way of counterclaim, the defendant avers as follows. Okay, the defendant avers as follows, and then you start from paragraph 1. So give us the version of your client. Now, what is your client claiming? Your client could be claiming that also on this day I loaned this person money and he never gave me that money. Or from the same facts, same facts as the plaint. Okay, same facts as the plaint, but now a different remedy. For instance, let's assume that I contract Saina. I contract Saina to deliver some bags of maize to my shop. 10 bags of maize to my shop. So Saina brings the bags and I don't pay him. I don't pay him. And then Saina sues me in a plaint. Okay. Saina will of course make a plaint and become the plaintiff and sue me for the value of the 10 bags that he delivered, but I didn't pay. Okay. Now from the same fact, once I defend myself until the last one, I can also bring a counterclaim against Saina from the same fact. Remember, the counterclaim must be from the same facts. They must be related. It cannot be something so different. Okay? It must come from the same fact. For instance, if I'm suing you for breach of contract, you can't start suing me for negligence. You can't counterclaim on negligence. Okay? Or if I'm suing you for negligence, I'm saying, oh, you are driving recklessly and you caused an accident and you injured me. You can't counterclaim and say breach of contract that, oh, 2 years ago I supplied something to you and you didn't pay. No, it must come from the same facts. So from this entire fact between me and Saina, him delivering 10 bags and me not paying, what is my counterclaim? My counterclaim would be, for instance, I will say on this day, so that is me writing my counterclaim, that, can see my paragraph 1, that the plaintiff and the defendant, plaintiff being Saina. And remember that when you're doing the counterclaim, you don't miraculously become the plaintiff now. You're still the defendant. You're still the defendant. So in the counterclaim, the defendant still is the defendant in the plaint, and the plaintiff is still the plaintiff in the plaint. So you don't change and become now the plaintiff. No. So you just proceed with the facts. So paragraph 1 will be saying that on this day, you don't describe parties in the counterclaim. So don't say that the plaintiff is no. Parties are already described in the first paragraph. And if you don't like the description in the first paragraph of the plaint, you respond to it in the defense by saying the defendant admits paragraph 1 of the plaint, but further states that his address of service is PO Box 234/1 Nairobi, not 231/4. So if there's a problem with the description of the parties, even you as a defendant, you correct it in the paragraph by saying the defendant admits, but further states that his email address is not this. Okay? Or if the plaintiff is saying that the defendant is a male adult of sound mind, if you stop identifying as male, now you're identifying as female, you'll be correcting that. You admits partly paragraph 1 or paragraph 2 of the plaint, but further states that as of this day, you identify as a female. So what I'm simply saying is, if there's a problem with the plaint, you address that in your defense. You correct that. Now, when it comes to the counterclaim, you're just giving your fact. So remember, our plaint, the one I'm trying to explain, Saina has sued me for breach of contract for what? Not paying for the 10 bags. Now, I'm also claiming something from Saina, and I'll be saying that on this day at this time, we had a contract with Saina to deliver 10 bags. Saina delivered the 10 bags, but upon my team, my quality team inspecting those bags, it was realized that those bags were rotten maize. Okay, that those bags were rotten maize. I called Saina and I told Saina to pay me or to redeliver other bags, but he refused to deliver. Okay. Reasons wherefore. I'm praying for what? So remember, I've done my counterclaim in that. I've just counterclaimed. I've given everything in the counterclaim. Okay. I've given that is all about counterclaim. So just give your fact that you're counterclaiming on. You don't describe the parties, you don't have the caption again, just give your fact that on this day, we had a contract with Saina. You're giving your version now. Saina gave his version in the plaint, you're giving your version in the counterclaim. We had a contract, and that contract, this and this, this and this and this and that. He failed to deliver or he delivered. It were rotten. I paid him a deposit. He refused to deliver me the right quantity of maize and that and that. And then after that, the normal things you put in a plaint. Okay, same thing. This cause of action arose within the jurisdiction of the court. Of course, that is obvious. That if you had demanded something from the plaintiff, again you say, despite the defendant demanding this from the plaintiff refused to do this. And then there's no suit, or there never been another suit between the defendant and the plaintiff in this regarding this cause of action. and then you go to your prayers. Okay, reasons wherefore, what are you praying for? Now, if you have specifics of this breach of contract, the same way you draft a plaint, you are going to have it there. Okay, so give your facts and then particulars of breach of contract. How did Saina breach the contract now? Delivering 10 bags of maize that were rotten. Okay, or doing this, and then if you have specific damages, and then reasons wherefore. What are you praying for? Okay, so when it comes to now the prayers, because it is a counterclaim and a defense, you're going to pray for everything there. That's all the prayers are going to be there. So first the prayers for the defense and then the prayers for the counterclaim. Okay, so what is your prayer for the defense? That the defense be dismissed. That is the prayer for the defense. For the defense, the plaintiff be dismissed. And then what is your prayers for your counterclaim? Special damages, general damages, and then lastly you're going to have the cost of the suit and any other relief or interest. And then you date and then you move on with your life. Guys, is that clear? Any person having a question, please ask. Somebody's saying, I can't see them on the lobby. Nobody's in the lobby. Betty, are you in? Betsy.
I'm in now. Thank you.
All right. So that is how you prepare these documents. So remember, counterclaim is just a plaint. The same way you write a plaint is the same way you're going to write your counterclaim, but you're not going to have the caption or the description of parties. Why? Because they're already described above in the plaint, unless you're disputing them, which of course you'll correct in the defense, not in the counterclaim. Any question? That is the end of drafting of pleadings. The next pleading we'll be drafting is a memorandum of appeal. Memorandum of appeal and the applications together with affidavits and originating someone under the applications. Yes, Kefa.
Yeah, I just need clarification on when you're talking about the jurisdiction of the court and the question of res judicata and the demand. Is there a specific order you need to follow, or you can start with any?
There's no order as long as they're there.
Okay. Thank you.
There's no order at all. Karaya, Evangeline.
My question is, what if you need to introduce another defendant in the counterclaim?
You can't. You can't introduce another defendant. How do you want to introduce another defendant? How? Maybe make it make sense. Tell me. What do you have in mind? How do you introduce another defendant?
No, under the civil procedure rules, right? There is, I think, let me just look for it. According to my reading, it seemed as if you could introduce another defendant in the counterclaim.
No, you really can't, and I wouldn't advise that. When you're counterclaiming, you're only counterclaiming against the plaintiff. But the instances could be that you're trying to sue. You're trying to sue two plaintiffs. You're trying to sue two plaintiffs in your counterclaim, which will not work again at the same time. You can't have two plaintiffs there. You only have the plaintiff that was there. But also, if you have, there are instances that have been discussed before. That you can have now. You can bring someone as a defendant in your counterclaim, where they're now counterclaiming with you. In the instance where the remedy in question, they're also interested in the remedy. Okay, though they were not sued by the plaintiff, you would want to bring them. It's a very complicated process that I would not want you to go through right now. I would just want you to stick to the basic of this, because bringing that person, also you'll have to start making an application for leave and have them be joined as a co-defendant in this one, and then they have to appear as defendants against the plaintiff, which, if you ask me, I will not advise you at all to go that route. So just stick to the defendant in the question and the defendant in, the plaintiff in the question. Are you together?
Okay. Okay, thank you.
All right. Okay. Okay, guys. So that is that. That is the question of preparation of pleadings, and then let us proceed and talk about something else. Let us proceed and talk about something else, and that something else is the question of service. Put you under
a small
question of service. Can you mute your microphone? Who's that speaking? I can hear someone speaking in the background. The microphone is on. Mute it. Okay. So our next discussion is really on the preparation of service and
Excuse
summons.
me, Mwalimu.
Put your hand down. Mute your microphone.
I have a question.
Just put your hand down and mute your microphone first. So our discussion after this is now the question to do with taking out of summons. But before we get there, I want you to go back. Okay, before we do anything, I want you to go back where we started and connect the dots. We started from instructions, factors to be considered before drafting a suit, jurisdiction, parties to a suit, courses of action, and now we have drafted. Now that we have drafted under order 4, we are now proceeding to go to order 5. Like I said, all these things are interconnected. From parties to a suit, order 1, all the way to drafting of plaints in order 4. Now we are going to order 5. So in the next 2 seconds, have that connected in your mind so that when we start the question of taking out of summons in 5, it's all making sense. Are we together? So you have 5 seconds to connect that in your in the back of your mind, and then we can start on the question to do with taking out of summons, and I will explain that. So let's take questions from Simel and then Okefa. As you connect the dots.
Okay, I wanted to ask, what is the difference of drafting a defense and counterclaim and drafting a defense and set off?
There's no defense and set off. Set off is part of defense. Set off is part of defense. So there's no pleading called set off. Set off is part of defense. So you plead it in the defense. A set off is a defense. Okay. If you know the difference between a set off and a counterclaim, a set off is a defense as a shield, while a counterclaim is a sword. Okay. So there's no pleading called a set off. So don't write it there. I know you've seen templates that have that there. Don't write it there. There's no set off is pled in the is in the statement of defense. It is part of defense. It's a defense itself. It's a defense. It's a way of responding to a defense by saying, okay, I admit and further states that this person also owes me this money, and therefore I plead set off. So there's no one. So you only have statement of defense, which is just defense, and then statement of defense, and then a counterclaim. Those two. Tuko sawa?
Sawa, asante.
All right, Kefa.
Yeah, my question is, in this counterclaim, it looks like the defendant is also instituting a claim against the plaintiff. Is there a possibility that the court can find both parties liable? So that
what do you mean? What do you mean it looks like? What do you mean it looks like?
Because I can see the defendant has a claim or his own claims against the plaintiff. So at the end of the trial process, is there a possibility that the court may find the plaintiff to be liable, and at the same time the defendant also being liable? There are two trials here.
So I think my network, I lost, but I'm getting. But what I wanted to tell you, is that is the entire essence of a counterclaim. There's no. The only reason why you have a counterclaim is because the defendant is also claiming against the plaintiff. So when you say that it looks like in this counterclaim, it looks like, then I don't understand, because the counterclaim, like I've already explained, is only there because the defendant is also claiming from the plaintiff. And yes, the counterclaim is different from the defense, and the counterclaim is different from the plaintiff. Okay, so the court can find all of them liable. Okay, the court can find all of them liable. The defendant is liable on the plaintiff, and then the plaintiff is liable on the counterclaim. So it's a possibility that all of them can be liable. Now, when that happens, if the court finds that in the plaintiff, the defendant owes the plaintiff 1 million, and then in the counterclaim, the plaintiff owes the defendant 300,000, then the court will order for a set-off, that amount be set off against each other, and then the defendant pays 700,000. I don't know whether you've understood what I've said.
Yes, thank you.
Yes, so if all of them are liable, then of course we have cross decrees. So we'll have a set-off against. The court says I should give you 1 million. The court says you should give me 2 million. So that one, let 1 million cancel the other 1 million, and then I pay you this. It's as simple as that. Because remember, they're different suits. The counterclaim is a different suit, and it's an independent suit. Okay, so yeah, that is the shortest answer. Githahu, Isaac.
Yes. Now, can you also reply to a pleading through a PO? And also looking at Mukisa Biscuits, it says that when you can only use a PO when all the pleaded facts are correct. So how do you go about that?
A PO is not a response. A PO is not a response. Okay? A PO is an objection to the entire pleading. So when you want to object to the existence of that entire pleading, you're not touching the substance of the pleading. You're not rejecting that there was a contract. You're not rejecting the liability. You're not saying that you've been sued wrongly. No. You are challenging the entire pleading on a question of law. Remember, the PO must be raised on a question of law. For instance, the court has no jurisdiction. Okay? If the court has no jurisdiction, you raise a PO. You don't do a defense. In that instance, you do a PO to challenge that the court does not have jurisdiction. If the matter is res judicata, then you raise a PO so that the court can throw away the matter, because it is a question that is res judicata or sub judice. Okay, so normally you raise a PO on a point of law. If the person that is suing is not a proper plaintiff, you raise a PO on that. So PO simply means that, hey, I don't even want to hear what you're saying. Throw away that document. If somebody comes to you and they're telling, there are two ways. You can entertain them. You see them at the door and they have a document in their hands. You can say, fine, open the document, and then you read the document and give them a response. But if you see them at the door and you tell them, no, my friend, get out. I don't want to see you or hear anything you want to say. That is a PO. Now, you're not challenging their document. You're not responding to what is in their hands. You are rejecting them as a person and everything else they're coming with. That is a PO. So POs don't respond to pleadings. You only raise a PO on a question of law that must be handled preliminarily before we get into the pleading. So if your PO is thrown out, then you have to prepare the defense now. If your PO is thrown out, then now you have to do a response to the pleading. Because
Yes. Now, looking at that Mukisa's case, does it mean then after the PO has been thrown out, then they will have indirectly pleaded? I mean, they have not. They have admitted all the facts.
No. That will not be used against them. It will not be used against them, and it depends on why they are raising. Why they are raising? Why? Because the question is very simple. The question is very simple. If for instance I bring a suit for 20 million in the magistrate court, you do a PO and challenge the jurisdiction. So indirectly, you will be admitting some facts of that. You'll be admitting the facts. For purposes of the PO, you'll be admitting the facts. But, okay, because remember, if it is 20 million that I'm suing you for, and you're raising a PO, you first have to accept it is 20 million. So that you can raise a PO and say, no, 20 million is too much for this court. So this is the court that doesn't have jurisdiction. But after the PO is thrown out, then the hearing in the PO cannot be used at the hearing of the suit if it is thrown out. You get the point?
Okay, yes.
Yes, and even if the PO is successful, it doesn't stop the plaintiff from going back and suing you properly now. Because if they file the matter in a different jurisdiction, in a wrong jurisdiction, and it is thrown out, the only thing they will have to do is just to correct the jurisdiction and go sue you in the proper court. So that is how it's handled.
Okay, thank you.
All right. I don't know that I've not answered any other question remaining, but I want us to go to the 5. So I hope you've taken time to reflect on our movement, because I said in the first class that civil procedure is very simple as you follow a specific formula. That formula starts from your office as the advocate, where your client will visit you, and you'll have to consider a few things. Okay, you take the instructions, you prepare the legal opinion, you prepare the demand, and then you prepare the fact. You get ready for the issues. Okay, somebody sent me a question. I don't know whether she's in this class. A question. I need that question so that I can project it and we can see it. I don't know. Are you here? Called who? I don't know. Come again. What's your name?
Marwa.
Yes, you are the one. Send me the PDF format of that question so that I can project it.
I only have a picture of it.
No, we can't project a picture. Which year is it?
I have no idea.
You need to have an idea, my friend. So look for it. Look for that question, and you can share it in your groups, and then they can give you the.
Give me a second. Give me a second.
The actual paper. All right. So let us go to the 5. Let us go to the 5, and I want us to talk about service of summons. Guys, move with me. Move with me. What did I say? Take instructions. Consider the factors to be considered before drafting a suit. Draft the suit. We have drafted the suit. Now we are filing the suit. Once we file the suit, we now take summons. Once we take summons, we serve the summons. Once we serve summons, the parties will enter appearance. Once they enter appearance, they'll file their defense. Once they file their defense, we will amend the pleadings. Once we amend the pleadings, we'll go to order 11 and start the pre-trial process. Okay, we start the pre-trial process, which is the pre-trial case management at order 11. After that, order 12, where we do the hearing. Okay, after the hearing, we proceed and do the interlocutory applications all the way, and then we shall go to order 21, where we talk about the question to do with judgment and decrees. After judgment and decrees, we go to the 22, where we extract decrees and execute decrees in 22 and 23. Okay, and then after that, we shall skip and run to 42, where we're appealing, and then go to 45, where we're reviewing, and then we shall be safe, home. Those are the only orders you need. Only those ones. So, like I've said, inaenda pole pole, pole pole, pole pole. So sahi tumefika 5. Tumetoka 1, parties to a suit, we discussed that. Drafting, it is from 2, 3, and 4. That is drafting of pleadings. Okay, now we are at 5, which is filing and taking out of summons. Now in this one, let us talk about filing and taking out of summons. Your hand is still up, Isaac. Isaac. All right.
Sorry.
All right, so I will spare some time. I will spare some 10 minutes or 20 minutes towards the end of the class to discuss that past paper question. It should be a question 1 on a few things and see whether you guys understood what we guys have been talking about. Okay. Perfect. So let us talk about taking out of summons. Like I have said, guys, once you file your pleadings, you take out summons. Now, in terms of taking out of summons, again, the most important thing is understand. Understand that is not taking out of summons. Understand that the stage you are in is the one on taking out of summons. So once you file your pleading, once you take out your pleading, that is you prepare your pleading, the plaint, okay? You prepare your plaint, or you prepare your statement of claim, you prepare your petition, you go and file it. Of course, as you file, you have to pay the filing fees. Filing what? Filing fees. Now, filing fees will depend. They could be as expensive as 100,000 shillings or even more. When filing fees alone can be more than 100,000, just filing fees. When you file a plaint, it depends on the value of the plaint. If the plaint is the more the money you are claiming, the more you pay in filing fees. So you could pay as much as 300,000 in filing fees. Okay, so you pay the filing fees. Okay, and then once you pay the filing fees, you file. Once you file your plaint, you take out summons. Now, summons is an order of the court inviting the defendant that, hey, you have been sued, and therefore come enter appearance and make a response. Come enter appearance and make a response. Are we together? So that is what happens when it comes to taking out of summons. So you take out summons. So summons is what is an order of court, sealed actually, that will tell the defendant that you've been sued. Come and enter appearance. Once you sue someone, don't go to their house and tell them, my friend, I've sued you. Go and enter appearance. No. You take to them summons. And these summons cannot be disobeyed. When you disobey the summons, that is contempt of court, jailer, 6 months. Okay? So you take out the summons. The summons are what are supposed to tell the person that they're being sued. It is the evidence of being sued. It's like when you send your parcel, you normally given a payment voucher or a receipt or an invoice. Okay, showing that you've paid and you have paid and you've parceled it. So it is the evidence of you paying and parceling. So you'll have it with you. And you could give it to the other person to reclaim the parcel. The same way, when you file a suit, the only thing that will tell me that you've sued me are the summons you've taken from court. And those are the things that you're going to serve. So you take out summons and you serve them upon the defendant. The summons must be accompanied by the pleading that you filed. Okay, so let us go. So when you're taking out of summons, you need to understand a few things. The first one is that summons are valid for a given number of time, but you have 30 days to take out summons. Guys, 30 days to take out summons. So if you file your suit today, which is the 31st of August, the 20 or 24, you take out summons within 30 days. So by the end of 31st of September, or the 30th of September, you needed to have taken out the summons. Okay, so you take out summons. The moment you file, the moment you file, the court clerk is supposed to prepare for you the summons. Okay, so summons, 30 days. Take them out in 30 days. Taking them out simply means file your suit, go back to court and get the summons. That is what you mean by taking out summons. You take them out within 30 days. Are we together? Perfect. Number 2, they must be accompanied by the plaint. You have to accompany it with a plaint. So you serve the summons and then the copy of the plaint or the copy of the statement of claim or the copy of the petition. Okay, that is what you use when you're accompanying the summons. And summons are standard documents. Somebody is wondering in the meeting that, can you be told to draft summons? No, they are standard documents. They're just downloaded and filled up and then stamped and then sent to you. So the third thing is that summons are valid for 12 months. So summons are valid for 12 months. Summons are valid for 12 months. So if you take out summons today, you have until the 31st of August next year to serve them. So you have 1 year to serve, 12 months. You have 1 year to serve. Are you together? You have 1 year to serve. So if you don't serve within 1 year, then the summons will expire, or you will have to go and apply for extension. So that is the third thing. So the first thing I've said, 30 days, the validity must be accompanied by a copy of the plaint. Okay, and then they are valid only for 12 months, and then they will expire unless you extend. So when do you extend? So if I take out summons to go and serve Anthony Waire, and I can't find Anthony for 1 year, then before my summons expire next year, let's say next year by July, if there's no chance that I'm still going to get Anthony, I go to court and tell the court, hey, please extend the summons for me. I've not found this guy. Extend the summons for me so that they don't expire. Okay? So you make an application for extension. An application for extension that is done in the notice of motion and the supporting affidavit. Now, guys, I know we haven't talked about applications, but you know applications. Drafting applications are very easy, very, very simple and easy. Applications are standard documents, like I've said over and over again. The only thing that will keep changing are the prayers and the grounds. Guys, imagine too, the prayers and the grounds. That is what will keep changing in all applications. So in this instance, what is the prayer? The prayer is the name of the application. It is an application for extension of summons. So that is the prayer. An application for injunction, that is the prayer. An application for amendment, that is the prayer. An application for review, that is the prayer. An application to strike out the pleading, that is a prayer. So guys, the name of the pleading will inform your prayer. And then the grounds, why do you want to do that? Very simple. Each and every, these things have the grounds every time. So if you are there, waking up at 4 a.m. every day to draft applications, you are mad. And I've said, don't do that. Don't do that. So if it's about extension of summons, wake up at 4 a.m. to read on extension of summons. Okay, but don't wake up at 4 a.m. to draft an application for extension. Okay, because that notice of motion will never change. It is the same one. What is going to change are the prayers and the grounds. So focus on knowing what prayers are you praying for and what are the grounds. For instance, when it comes to application for extension, the first thing you want to know is, when do you apply for extension? And it should be somewhere at the back of your mind. Apply these things in real life. It should be something at the back of your mind. So when do you apply for extension? When you have tried serving the defendant, but you can't find the defendant. You can't seem to find the defendant. So in a question where you're being told that this person or your client has been trying to serve the defendant for this number of years or this number of time, but is not able, And you can also see that the the summons are almost expiring. Then you're told to prepare the necessary application. It is simple. You need to extend the summons. So what are your prayers? That the court do issue an order extending the summons dated this and this date. Full stop. Number 2, cost, if it is needed. If you don't want it, one prayer is enough. Grounds, what are your grounds? Very obvious again, no complications. Number 1, that you took out summons, you tried serving, you are not being able to find it. Okay, that is the ground. And your summons are almost expiring. Those are the grounds, guys. And then you go to your supporting affidavit. The same story, whatever is in the question, whatever you put in your grounds, expound it on the supporting affidavit. The difference between the grounds and the supporting affidavit is only one. Okay? The grounds don't contain evidence, but the affidavit contains evidence. For instance, you'll be saying, one of the grounds is that I have not been able to, or I've been trying to serve this person for a number of years, or I have been able to send emails to him without finding him. You can say that in your grounds. However, when you say that in your supporting affidavit, you can say the same thing in the supporting affidavit, but you have to give us evidence now of what you're saying. Okay, that I've been trying to serve, or the applicant has been trying to serve the defendant for through the email, but the emails have been returned as undelivered. And then you put into paragraph attached herewith and marked AB1 is a copy of the emails. Okay, so whatever document you're relying on, you put it there. But you only do that if the examiner has told you that those documents are existing. If you're not told, just have a plain supporting affidavit and move on with life. So guys, drafting applications, very easy. Whatever you are praying for and why you are praying for it. It's like asking for money. I've used that example a lot of times. When you ask for money, that is a prayer. You ask for money. Why do you need the money? Fees, pocket money, whatever, food, rent, all those things. Okay, so that is the question of extension, application for extension of pleadings, sorry, of summons. So notice of motion, supporting affidavit. That application must be brought under the specific rules. Okay, can bring it under order 5. If you don't know order 5, you can bring it under order 51. If you don't know order 51, you can bring it under section 1A, 1B of the Civil Procedure Act. And then if you don't know that, you can bring it under Article 159 of the Constitution. Those are the obvious sections. They are what you call the default sections or provisions that you can bring an application under if you forget order 5. Okay. Okay, so that is application for extension. I know somebody is trying to ask me to repeat that, which I've already repeated in every class. Na kuona sana hapo. Na kucheck okay. Okay, so that is application for extension. And then we have something we are calling the concurrent summons. So sometimes you want to serve this person, you have to make different attempts at serving this person. Okay, so you have process server in Mombasa to have a copy of the summons, and also you want your server in Nairobi or somebody in Kisumu to try and trace this person and serve him. So, okay, but you don't know which one or who will be successful. So you can apply for another copy of the summons, another copy of the summons. Give me 1 minute. All right, you can apply for another copy of the summons. So that is called a concurrent summon. So concurrent summon simply means that the same summons are the same summons that you took. Okay, same summons that you took, but you're given 2 original copies, 2 copies. So concurrent summon and the main copy. So this concurrent summon, you can serve it anywhere. Or if your main summons disappear, if you lost or destroyed the original summons, you can go and take the concurrent summons. So concurrent summons are just the alternate summons, and they run concurrently with the original summon. So if you're given summons in January, and then you want to apply for concurrent summons in June, then you'll be given concurrent summons for 6 months only. That is the remainder or the remaining time of on the original summons. I don't know whether somebody understood that. If you don't understand that, you put up your hand and ask a question. That is concurrent summons. That is concurrent summons. And then we have the question to do with the dismissal of the suit for non-service, okay, which is 24 months. So let me explain. When you take out summons, the moment from the time you take out summons, you have 12 months, okay? You have 12 months to serve them, okay? If you don't serve them within 12 months, you need to apply for their extension. So if you don't apply for the extension, then the summons will expire, okay? From the time the summons have expired, the court will start counting 1, 2, 3, 4, 5, 6, 8, 9, 10, 11, and the 12th month. On the end of the 12th month, your suit will be thrown out, will be dismissed for want of prosecution. Right, together, it will be dismissed for want of prosecution. So what am I saying? So you have 1 year to serve. If you don't serve within 1 year, you either apply for extension. So if you don't apply for extension, then the court will start counting. So at the end of the 12th month or 1 year after the expiry of your summons, your suit will also be thrown out for want of prosecution. So it cannot be thrown out for want of prosecution, which is 24 months from the date of the initial summons. That's why it is 24 months. So 12 plus 12. So you take summons today, 12 months, you serve it. If you don't serve it within 12 months, then it expires, and then you have another 12 months, and then the court will dismiss your suit. So that is the effects of not extending summons. If you don't extend summons within the time provided, they will expire. Once they have expired, then you can either apply for extension out of time, okay, or your suit will be dismissed if you don't do nothing about it, okay? Remember, the suit will not proceed until the person has been served. The suit will not proceed until the person has been served. Whether you can't find them, you have to serve them. So if you don't find them and you don't serve them, there is nothing for you. The suit cannot go ahead, okay? That is what we're saying. So you have to serve them. If you don't serve them, there are other ways of dealing with that if you don't serve them. So that is the question of taking out summons. Taking out summons and the validity of summons and the timeline or the lifespan of summons. Questions on that before we get to now the question of servicing or serving these summons. All right, service. So in terms of service, guys, we have seen summons taken out. We have seen summons taken out. Now, let us go and serve them. You take them out and you serve them. And I've said, take them out within 30 days from filing. Once you take them out within 30 days from filing, you proceed and serve them within 12 months. If you don't serve them within 12 months, the court will dismiss your suit after 12 months of their expiry. And then we have said, summons must be accompanied by a copy of the plaint. And if they are going to expire, you can renew or extend by making an application to court through a notice of motion and a supporting affidavit. And you are going to ask the court to extend them for you, and the court can extend it at any time. If you want concurrent summons or other summons in the same matter, you can apply for concurrent summons. That is all I've said in terms of taking out of summons. Now let us talk about service. Service. How do you serve? How do you serve? So in terms of how do you serve, it is important to note a few things. The first one is who can serve. That is the most important thing. Who can serve? Not every person can serve. Not every person can serve. Who is this person that can effect service? Not every person can serve. Some of you here are already serving. Some of you here are already serving. Pupils in law firms are already effecting service. My friend, you will go to jail just for effecting service. You will go to jail. So tell that advocate of yours. Yeah? Let that associates. They're usually associates. I don't know what's wrong with associates in law firms. They're just associates that like sending pupils. You rarely find partners sending pupils. It is just these 2 years, 3 years associates that are feeling that the firm is theirs. So pupils are not supposed to serve, okay? They're supposed to learn, and then they become advocates, and then they serve. Service of summons is not for pupils, please. So the first question is who can serve and how do they serve? So somebody to read for us 5. That is order 5, rule 5. I am projecting it on the screen. Read it very clearly. Penina?
Oh, yes, Mwalimu. Order 5, Rule 5 of the Civil Procedure Rules, delivery or transmission of summons for service. Where the court has issued summons to a defendant, the summons may be delivered for service to any person for the time being duly authorized by the court, to an advocate or advocate's clerk approved by the court, to any subordinate court having jurisdiction in the place where the defendant resides, to a police officer appointed under the Police Act, Cap 84, or to an officer appointed under the Administration Police Act, Cap 85, or to a licensed carrier service provider approved by the court. Shall I move on to 2?
No.
Okay.
So did you see anywhere written pupils? Nowhere. Nowhere. Pupils are not supposed to effect any service on anyone. So tell your pupil master that they're sending you to committee just by doing that. When you're caught, of course you will not be caught. They usually say until it is your day. And then boom. So pupils are not supposed to serve. So don't serve as a pupil. So let us go through this number at least again. Number 1, any person that is authorized by the court. We call them court process servers. They are duly authorized and licensed by the court. They are court process servers. Okay. Number 2, so you have to attend a training. You have to attend a training and you be licensed as a server. Okay. An advocate of the High Court of Kenya, of course, they are licensed to serve. And then the advocate's clerk. Now, in law firms, you've seen clerks in law firms. These clerks in law firms, they do service. Okay, they do service. But before they do service, they have to be approved by the court. Not every clerk in the law firm will do service, because guys, when service is disputed, the person that served will be called and will be put on the stand. And then you will be asked, who are you? Are you a server? And then you'll say no. And the judge will just say, nitie polisi hapo ndani. And that is how they get ndani. So when service is disputed, the person that served must come and stand on the stand. Okay? I am projecting. So if you're not seeing it, leave the class and come back. I'm projecting the screen. Guys, can you see my screen? Somebody just read it, so I think it's being visible. Okay, so the person that is a licensed court process server, an advocate of the High Court, the advocate's clerk who has been approved by the court, any subordinate court, a magistrate court. So the High Court judge can direct a magistrate to serve. Magistrate can serve. A police officer that is duly appointed under the Police Service Act to effect service. Okay, and a licensed courier service. So we could have the licensed courier services. These people that they do deliveries of summons. So if you want to serve, maybe it could be FedEx, DHL, or just the local ones that we have. G4S, we could have G4S who is now licensed to a G4S officer or G4S service that is licensed to effect service upon the defendants or any party. So they have to be licensed by the court. Okay, so those are the people that can serve. Those are the people that can serve. Okay, and of course, the plaintiff himself. The plaintiff himself can serve. If you're appearing in person, you can always serve. If the suit is yours, if you're a party to that suit, you can always effect service. Okay, so those are the people that can serve. So you need to know the people that can serve. Guys, people that serve are equally important, just like who they serve and how they serve it. Okay, because remember, if you serve as a pupil and the other person refuses that you didn't serve them, then you'll have to serve again. Okay, you'll have to serve again. If you're the pupil, you effect service on someone and they know you're a pupil, they will accept the service. And then if they're sharp practitioners, they will say, no, I wasn't served by anyone. I wasn't served by anyone. Now, at that moment, you as a pupil cannot swear an affidavit and say that, but I served him. Who are you to serve him? Okay, and that is where you will just count your losses and say, no, I didn't serve him. So you have to serve him again. So that is how people buy time. Okay, but I will talk about the alternate side of it. I'll talk about the alternate side of it right now. Now that is the person that can serve, who can serve. And then now let us talk about how to serve. That is how to serve, and that this means service on different people. So we start with service on a company. How do you serve a company? How do you serve a company? That is a corporation. How do you serve a company? Order 5, Rule 3, it says, subject to the provisions of any other written law, where the suit is against a corporation, the summons may be served on the secretary, the company secretary. Number 2, the director of the company. Number 3, any other principal officer of the corporation. Or if the process server is unable to find any of the officers of the corporation mentioned in Rule 3A, the service may be done by leaving it at the registered office of the corporation, by sending it by a prepaid registered post, by giving a licensed courier service, which of course licensed and approved by the court. And then if there's no registered office and no registered office or physical address of the corporation, by leaving it at the place where the corporation carries on business, and then by sending it to the registered post, the last known postal address of the corporation. That is how you serve a company. But there are 3 more aspects I'm going to explain. So the first thing, serve the secretary, give it on his hands or her hands. 2, a director, or a principal officer in that company or that corporation. And then take it to the registered office. If they have an office that you know, go to that office. Or you can serve them through a prepaid registered post. You can give it to a licensed courier service who will serve them on their a registered postal address, PO box. The postal address, the PO box. We have the physical address and we have the postal address. What is the difference between those 2 things? Somebody, what is the physical address and the postal address? What is the difference? Who? Should I call somebody's name? Mora Omwenga?
Physical address is where the office is situated, while the postal address is where mails, letters pass through.
What do you mean when mails pass through? Give us an example. Give us an example.
A poster, that is.
Give us an example of what is your physical address. Don't give us the exact place, but give us an example of what your physical address would be and your postal address.
Chester House, room, let's say 3 or 4.
That is your
postal physical address.
Yes.
The postal address can be 9096 00 0100, something like that.
What you're not saying is the PO box. So the postal address must have the PO box. Postal office address, PO box. So postal address, PO box. And then the physical address is the physical address of the office. So it's Chester House, 2nd floor, room number this. That is a physical address. So that is how you serve. And also, if you can't find all that, you have to you send it to the registered postal address or the last known postal address. Okay, so that is how you serve upon the company. That is service upon the company. The next thing is, how do you serve a person? You want to serve a physical defendant that is not a person. There are various ways of serving a person. Oh, sorry, before I forget, you can serve the company through the amendments. We have amendments under Order 22, Rule 22, which is the mobile-enabled messaging apps. If you know the company's official number that has WhatsApp, you can serve them on WhatsApp. You can serve them on email. Okay, you can serve them on email. And also you can serve them through the registered, internationally recognized courier services. Are you together? So that is how you can serve. That is how you can serve a company. That is how you can serve a company. Are you together? That is service upon the company. All right, how do you serve a person? So the first one, you serve a person by giving it on their, placing them on their hands. Give them physically. Hey, this is the service. Okay, these are the summons. That is the first way. Serve them in person. Number two, you can serve them at their last known address. That is a home address where they're staying. Go to their home and serve them there. Go to their office and serve them there. Go to their place of business and serve them there. You can serve their agents if they have registered agents. For instance, you know their advocates. Go and serve their advocates. Okay. You can serve them through their email, through their registered postal address, through their WhatsApp. That is the mobile-enabled messaging apps. You can serve them through all that. Now, if you can't find them, in all that, you can leave the document. You can leave the document either pinned on the door, or you slip it under the door. That is of their residence where they're staying, their door. So if you go to their house and you can't find them, you can leave it on the door or slip it under the door. That is how you serve a person that is a natural person in the company. And then how do you serve in prison? Of course, you serve the officer in charge of the prison. You serve the officer in charge of the prison. That is how you serve in prison. How do you serve the public officers and officers of the army? Public officers and officers of the army. Now, if you can't serve them in person, you serve them through the headquarters. So if it's a public officer, you go to the office, the headquarters of the office. Okay, so if he's a member of, if he's working for the Ministry of Lands, you go to the office of the Ministry of Lands and serve him there, or leave that document there. And if he's a person that works in the army or a member of the armed forces or the army generally, you proceed and serve the commanding officer. The commanding officer is the one that is served for persons that are in the army. So I've said prison. I've said persons that are public officers and persons that are in the army. And then how do you serve the government? How do you serve the government? The government is served, of course, through serving the AG. You can serve, of course, the government itself through their agents. That is, if you know the advocates in question. You can serve the AG. Of course, the AG is usually the default service. You can drop the documents at the AG's office within the working hours. So that is 8 to 5. You can drop them there. All right. Now, how do you serve outside the country? How do you serve outside the country? Service upon a defendant that is out of the country. Now, before you do that, before you understand the question of service out of the country, you need to understand when you can serve out of the country. When can you serve out of the country? It's very, very important. I want somebody to read that for us. When can you serve out of the country? Somebody is in Uganda. Okay, somebody is abroad. Okay, how do you serve out of the country? Somebody is in Tanzania, South Africa, the UK, the US, Asia. How do you serve them? Okay, how do you serve them? Now, before you understand how to serve them, it is important for you to understand when you can serve them, because not all the times you can serve them. Okay, so if you look at Rule 21, sorry, it provides for instances when the court will allow you to serve out of the country. Okay, so the first one is number 1, the whole subject matter of the suit is immovable property situated in Kenya. Okay, so if it is land, if you are fighting over land, that land is in Kenya. It is land that is in Kenya or a building that is in Kenya. So that allows you to serve outside Kenya. So the subject matter of the suit is an immovable property situated in Kenya. That is the first rule when it comes to when you can serve abroad. The next one is any act, deed, will, contract, obligation, or liability affecting immovable property situated in Kenya is sought to be construed, rectified, set aside, or enforced in the suit. Okay, the suit is all about enforcing a right or a contract or a liability relating to this immovable property that is in Kenya. Okay, so the suit property, the subject matter of the suit is a property in Kenya, or any order that is being sought in that specific suit is going to affect an immovable property in Kenya. Guys, are we together? Number 3 is any relief is sought against any person, domicile, or ordinarily resident in Kenya. So if any of the suit or any of the reliefs that you're seeking, is sought against a person that is domiciled in Kenya or ordinarily a Kenyan resident, then you will be allowed to serve abroad. Okay, so generally what we're saying is that suit must be related to something in Kenya. Okay, D is that the suit is for the administration of the personal estate of a deceased person who at the time of the death was domiciled in Kenya, or for the execution of trust of any written instrument of which the person to be served is a trustee, which ought to be executed according to the laws of Kenya. So we are saying you want to administer the estate. If it relates to administration of the estate of the deceased person who was domiciled in Kenya, or the question of execution of a trust that was intended to be executed according to the laws of Kenya. Okay, and then 5, the fifth one is the suit is brought to enforce, rectify, rescind, dissolve, annul, or otherwise affect a contract, or to recover damages or other relief in respect of a breach of contract made in Kenya, or a breach of contract made by or through an agent trading or residing in Kenya. Are you together? So it's the whole list, or a suit founded on a tort committed in Kenya. So exactly what I'm saying, in short, let me summarize it, that whatever you're seeking in that suit somehow affects a property, or a person in Kenya. Okay, that is when you're allowed to serve abroad. So either the land is in Kenya, the suit property is in Kenya, or an order that is sought that is going to affect a property in Kenya, the breach of contract was committed in Kenya, or the contract was concluded in Kenya, the tort was committed in Kenya, and so on and so forth. That is the ground for serving, the grounds for service in Kenya. So when you are serving out of the country, the first thing you have to do is you make an application to court, notice of motion, make an application to court for leave to serve out of the country, leave to serve out of the country. And you'll have to give us the ground. So your grounds will be either one of these things, that number one, the defendant is a resident or the defendant is staying out of Kenya. That is the first one. The defendant is staying out of Kenya, number one. Number two, the question of all the things I've mentioned. So one of them, just pick one of them, that the contract was concluded in Kenya. You'll be told in the question, the relationship between that suit and the person who you want to serve abroad. Are we together? So that is how. So the court will give you leave and then you serve through the course there. The ordinary, there are two ways of service. You can serve through the Ministry of Foreign Affairs. The Ministry of Foreign Affairs, that is the traditional way of service. You transmit that through the Ministry of Foreign Affairs, through the diplomatic missions. Number two, you can serve through the emails. Okay. Number one, you can serve through the email. Number two, you can serve through the mobile enabled messaging app. Number three, you can serve through the internationally recognized courier services. Internationally recognized courier services. Are you together? Internationally recognized courier services. That is how you serve abroad. So traditionally, before the amendments under Order 20 or Rule 22, you could serve through the Ministry of Foreign Affairs, where those summons, once you have the leave, you'll have the summons transmitted through the diplomatic missions, the Kenyan High Commission, to the Ministry of Foreign Affairs, and the same will be transmitted all the way to that person, and of course through the diplomatic channels. Now, after the amendment, now there are three other ways of effecting service. There are three other ways of effecting that service. The first way is through the mobile enabled messaging app. Number two, through the emails. And number three, you can always serve through the internationally recognized courier services like the DHL, FedEx, and so on and so forth. That is how you address the question of service out of the country. Now, let us talk about the last few things, which is the question to do with substituted service. Substituted service. Unless somebody is having a question, let me proceed. Anyone with a question? Or you can take questions at the end. Still fair. All right, so what is substituted service? It's a very simple thing. I don't want to complicate it and confuse you with it. It is very simple. Okay, substituted service. Now, substituted service from the word substitution is whereby you are serving in a way that is different from the normal way of service. Why? Because you could not find the defendant. In an instance, guys, where you can't find the defendant, in an instance where you cannot find the defendant, you tried serving him all the way. I mean, you tried everything possible, but you can't seem to find him. Then you will apply to court and have the court give you leave to have what you're calling substituted service. Okay? Now, what are the modes of substituted service? Number one, you go and pin the service at the courthouse. You go to the courthouse, go to court and pin that summon on the notice board. That is a substituted service. Now, it is deemed that when you pin it there, somehow, this person will see it. That is what the law assumes. Okay? You pin it at the courthouse. Number 2, you pin it at the defendant's house. You pin it at the defendant's house. You go to the defendant's house where he's staying, and then you pin it there, or where he used to stay. Remember, you can't find it. So where he used to stay, you go there and you pin it on the door or on the wall or any conspicuous space. Okay? That is another mode of substituted service. So you just go and pin it there or pin it at the courthouse. The next one is service or publishing that summon on a newspaper, a daily newspaper. Okay? Daily newspaper that has a nationwide circulation. So once you do that, Daily Nation, Standard, all that, once you do that, the law assumes that somehow this person will take time to read that newspaper for that day and will see him being served. That is substituted service. Substituted service, guys. Tuko sawa? So once that is clear, please tell me it is clear. So that is substituted service. So it's different. So pin it at the courthouse, at his old house where he used to stay, and then you can also have it at the newspaper. You can publish it in the newspaper. That is a daily newspaper. Okay. Now, how do you do substituted service? The first thing you have to do is to make an application to court. Make an application to court for substituted service. Now, when you are making an application for substituted service, what are you praying for? Somebody tell me what you're praying for and the grounds. It is a notice of motion. What are you praying for and what are the grounds? Guys, I've said notice of motion is just a notice of motion. It will never change. It's a simple document. It will never change ever, ever, ever. So what are you praying for? Banafa Abdul Kadir. And you give us the grounds as well.
Okay, for the orders, it will be that the Honorable Court grant leave to the plaintiff to effect substituted service. Maybe the other order would be that the cost of this application to be catered for.
The grounds?
The grounds would be that the plaintiff had tried to serve the defendant through the various means, but is unable to do so. That the plaintiff there is need to serve the plaintiff. That there is need to serve the defendant before the summons expire, and that it is in the interest of justice that the summons be served.
Yes, you said a lot of things. Yes, you can have all that. There is no problem. Or have the first ground you said. So guys, that is exactly how you prepare that application. It's very simple. See story mingi. Just leave. The court do issue leave to effect substituted service upon the respondent or upon the defendant. You will have to list the name there. Okay. Number 2, you could pray for cost if you want, and then you go to the grounds. What are the grounds? The grounds are very specific and very simple. Number 1, that you've tried, and the grounds are always in the question. Always remember that the grounds are always in the question. Grounds are always in the question. Always remember that grounds are always ever in the question. So that is what you need to understand. Grounds are in the question. So the grounds are very simple. Like I've also said, that you tried serving this person, you have tried effecting service on this person, but for some reasons you can't find him. For some reasons you can't find him, and the details will be there in the question. How much you've tried will be there in the question. Okay, so that is exactly how you handle substituted service. Okay, so once you get that leave, you shall proceed and publish that notice in the Kenya Gazette. And guys, something I've forgotten to mention. When you apply for substituted service, you have to say exactly how you want that to happen. Okay? You have to say exactly how you want to serve. So leave be granted to institute substituted service upon the defendant by, you have to tell us by what? By publishing the summons on the Kenya, on a daily newspaper. You have to specify the daily newspapers as well, Nation or all of them, or by pinning that at the courthouse. You have to specify how you want to do that. Are we together? So that is also very, very important. Very, very important. All right, guys. So that is all about the question to do with substituted service. So notice of motion supporting affidavit. Notice of motion supporting affidavit. What are you praying for? Leave to substitute. Leave to initiate or to effect substituted service upon the defendant. Okay. By, you have to tell us by how. How do you want to effect it? Publishing it in the Kenya Gazette, a daily newspaper, pinning it at his house, or having it at the courthouse. And then if you get the leave, you shall proceed and do exactly what you prayed for. And then you shall file your affidavit of service. Affidavit of service. And then after that, the court will wait for a service, because the court will effect service. The court will indicate the service period. What I mean by that is, when you make that application and you get the orders, the court will indicate that the applicant is hereby granted leave to effect service by way of substituted service by publishing the notice on the daily newspaper or pinning it on the courthouse and whatever you prayed for. And then the court will also indicate that the defendant is required to enter appearance within 14 days, within 7 days, or within this number of days after the date of that service. Okay, so that means that 15 days after the date of service, the matter will proceed as if the defendant was served and he could not enter appearance. That is substituted service. You substitute the service. Okay, so that is what we're saying. So the modes, I've already discussed the modes, and then the orders, the prayers, you proceed and publish it in the newspaper, and then you prepare your affidavit of service. Affidavit of service. So our next discussion is the affidavit of service. How to prepare an affidavit of service. How to prepare an affidavit of service. Have all the questions ready, because this is the last thing I'm doing on service, and then we can take questions. Have all your questions ready on service that you don't understand, so that we can discuss them. Okay. Affidavit of service. Let me see if I have one here. Let me see if I can project it. Yes, I can. Can you see my screen?
Yes.
Okay, affidavit of service. All right, so essentially, when it comes to affidavit of service, you're just telling the court that I swear that I served. I actually went and served. That is exactly what you're telling the court. Affidavit of service is not crazy. It's just evidence of service. Remember, parties, what is the rule? One of the rules of natural justice is that no person should be condemned unheard. So court must be very sure that this person that you want to get orders against, did you serve them? Do they know that there's a matter in court against them? So for the court to be sure, the court will want you to serve. And once you serve, you have to file an affidavit of service that, yes, on this day, at this time, at this place, I went there and I served them. Once I served them, they stamped my copy and they remain with their copy. And therefore, I come back to this court to report that I actually served. Full stop. Okay? But you have to be, for you to swear an affidavit of service, you must be a person that is licensed or approved to serve under Order 5 Rule, Order 5 Rule 3. Are you together? Now, the normal thing, caption of the case, parties, the name of affidavit of service, that is affidavit of service. I, person XYZ of that in the Republic of Kenya, do make oath and state as follows: that you are an advocate of the High Court of Kenya, practicing in that firm. And then you don't have to state all these things. You don't have to state all these things. Okay. Just indicate that you prepared a hearing, whatever you're serving. If you're serving a defense, if you're serving an application, if you're serving a plaint, just say you prepared a plaint dated that day and caused the same to be served upon this person. I think this legalese will fail you guys. I don't trust you guys around legalese. I don't trust you guys around legalese. Some of you are already cramming legalese. Let me bring up a document that is not legalese and draft it from scratch. For instance, this one here. So let me capture the caption there. That is the problem with this with you guys with the legalese. When you see legalese, your brain starts functioning differently. So let's draft it from scratch so that you guys can see. All right, I'm projecting a document. In practice, guys, people will say a lot of things. People will say a lot of things when they're drafting that. Whatever I'm showing you is something we used to do in practice. It's a practice document. So you'll find a lot of nonsense in it. A lot of things are not relevant. Okay. So let us draft this one from scratch so that you can see. So affidavit of service. Essentially, once you have that, Control E, you're going to have affidavit of service. Okay. So essentially, affidavit of service is you just telling the court that you served. Okay, that you served. That is all. The court needs to be sure before the court moves forward. Before the court moves forward and makes an order, the court must be sure that you actually served, and the court cannot trust your word. You can't just tell the court, yes, I served. That is not enough for the court. The court needs something, document that can be used against you. So that is an affidavit. So just write an affidavit of service and just indicate that I, XYZ of PO box, that one, Nairobi, do make oath and state as follows. Okay, state as follows. Number one, that you are an advocate of the High Court of Kenya. Okay, you're an advocate of the High Court of Kenya, and therefore you have to ascertain your competence first. So in terms of saying you're an advocate of the High Court of Kenya, you're actually stamping the authority that you have the authority to serve. If you're a licensed court service, court process server, you say that. Whoever the person you are, you will be told in the question. Of course, you will be an advocate all the time. So that I am an advocate of the High Court of Kenya, hence duly authorized, authorize this way, this affidavit. Okay. Full stop. That on the 22nd day of March 2024, I prepared. What did you serve? Maybe you served what did you serve? Serve an application or a hearing notice. Let's say a hearing notice. I prepared hearing notice. I'm not paying attention to capitalization and punctuation because of time. A hearing notice dated the same day and proceeded to effect service upon the defendant or the defendant. Okay. Now, third one, just tell us how you served that at around 2 p.m. on 23rd March 2024, I proceeded to the defendant's advocate's office office. Am I typing? You are the name of that law firm. What is the name of that law firm? Let's say XYZ Advocates LLP. Okay. Going to be where I served the said notice upon Mr. Who did you give? You have to say the person you gave. You gave an advocate, or you gave a clerk, or who did you give? Okay, upon Mr. XYZ, an advocate in the firm. Okay, that the same was received and my copy stamped. Okay, my copy stamped. So guys, are you seeing how this is I mean how this is prepared? It's very simple. Are we together, guys, or I'm losing you?
Yes, we're together. We're together,
Okay.
Mwalimu.
Okay. So once you write that, the same was received and my copy stamped, and then I now therefore return the said notice, the said hearing notice. You return it to court. Once it is, you are returning it to court essentially. The said hearing notice to this court as duly served. You return it as duly served. That is that you are making a report. I return it as duly served. Okay. Then you come and say sworn, the normal thing, sworn at Nairobi this dash day of dash 2024. Okay, this dash day of dash 2024. Before me, no, sorry. By the said, whoever was signing the affidavit, by the said dash, and then you'll have a space for signature there. Their signature. We'll have a place for signature there, and then before me, and then after that, you have drawn and filed by to be served. Drawn and filed by to be served upon. Okay, drawn and filed by to be served to be served upon. Remember, the person that swears the affidavit does not, the person that commissions the affidavit does not draft the affidavit. So here, before me, can you see the before me? So the person that is going to be before me is a different person who is not from this law firm. Drawn and filed by is a different law firm. For instance, BBBBB Advocates LLP. This person will have to be someone different and not a law firm normally. It's a person, a commissioner. Because after that, you have to write commissioner. Whatever I'm explaining right now, I think you guys understand. I think you guys know it. What am I writing? Commissioner of what? Okay. So to be served upon that is the normal things, guys. Normal things. But they said that person, the name of the person that swore the affidavit there, the name there, and then the signature there, and then the stamp of the commissioner for oath there. Don't write anything. Some of you are very crazy. Some of you will start creating and drawing stamp there and writing XYZ. Don't draw the stamp. Okay, guys, you can't create a stamp in an exam. Don't be too creative. So that place is usually blank because it is a stamp that will be there. Don't draw something there with a pencil and then write so and so. No, don't be like that. Okay? Life is not that serious. Just leave it blank and write commissioner for oath and then come down here and say drawn and filed by to be served upon. Full stop. This is your affidavit of service. So essentially, you're simply telling us that I prepared this document. If it is a plaint, dated this day, I proceeded to this place and served that document. Okay, I served it upon this person on this date. What did they do after you served them? If they refuse, if they beat you, they say I served them, but they beat me like a dog before I left there running. You say all that. Okay, you say all that because remember, if you serve and they beat you, that is contempt of court and they have to be punished for that. And yes, people beat process servers. That's why I'm trying to look out for you guys. And I'm trying to tell you, pupils don't serve. You will be beaten for no reason. And the law firm doesn't pay you enough to be beaten. Okay? So don't stay away from service. Some people are very crazy. Some defendants are very, very crazy. They can even chase you with a panga just because you're serving them. Okay? So if you must serve, just serve them on WhatsApp and take a screenshot and prepare the service. So again, if you served on WhatsApp, you have to take out the screenshot of that message that is indicated as delivered. The blue ones. Again, some of you are very wicked. The WhatsApp, you'll never know whether they delivered it, whether it was read. It is just one tick or just two gray ticks. You're wondering, what are you hiding? Guys, when you download your WhatsApp, the default is when somebody sends you a message and you read it, once it is delivered, it is double tick, gray. Once you read it, it is blue. That is how WhatsApp was meant for people to communicate. But you guys now get in there, start getting creative. You deactivate the blue ticks or you remove the two ticks. Now somebody's wondering, did this person see my message or not? What are you hiding? There's nothing you're hiding. It's not that serious. Please, be normal. So if you serve somebody on WhatsApp, sometimes it's very hard to know whether they receive it or not. But serve them, and then you will have to take a screenshot of that and then print it out, and then you will indicate here. For instance, you'll just write that on this day at this time, I served them through their WhatsApp mobile number XYZ 07 this and this and this and this, which was delivered at this time. Okay, and then you write attached herewith is a copy of the screenshot. If you serve them on email at the same time, print out the email and attach it in the affidavit. If you serve them through registered postal address, indicate there that you serve them through the registered postal address. and you attach the receipt. Whenever you serve through the post, normally they give you a receipt. So attach the receipt to show that you actually sent it through their post. That is how you deal with that. And please, if you are on WhatsApp and you've deactivated those things, you know something, I don't know. Sometimes I just sit down and wonder, what is wrong with people? How does it get to your mind? How do you just sit down? Umekaa tu kwako vizuri, unanyamaza, maybe umekula, unatulia tu. And then your brain just tells you that, by the way, I don't like these blue ticks. Let me remove them. How does it get to that point? Some also will set, I don't know, disappearing messages. That your messages now, you want all your messages to disappear within 24 hours. I mean, tell me, make it make sense. How does it get there? What do you need to think about until your brain gets to the point where you're saying, okay, now I'm removing these messages. I want them to disappear. I mean, you guys are really thinking. You're thinking too deep in this life. Guys, relax. Come on. Don't be like that. That is, you're really thinking too deep. Umekaa tu chini ukaona hii WhatsApp. Hii message was a kind disappearing. And then I send you links. You know, the beauty of it is I send you links. And your WhatsApp is set at disappearing 24 hours. And then after 24 hours, you're coming to me again that, oh, the links disappeared. Hey, my friend, you will meet the head of the river. Have you ever met the head of the river? So if you set your message to disappear after 24 hours, hey, I will deal with you when you come back with the links. You will have to call WhatsApp people to send you those links. Just be normal, guys. Just live normally. Why do you want your messages to disappear? Okay. Make phone calls then. If you don't want records of your message, just make phone calls. Just call someone and tell them, hey, send me this. And then that is word of mouth. It disappears after it's said. Guys, that's how you serve. That's how you prepare your affidavit of service. That is all it is. Now I want to take questions, and all questions, guys. Please, please, please ask all questions. Ask all questions regarding service. Our next discussion is amendment of pleadings. And once we're done with amendment of pleadings, where's my course outline? Once we're done with amendment of pleadings, which we'll do in the next 30 minutes in the next class, we shall start talking about the interlocutory application. Now, this is the most interesting bit of civil. Interlocutory applications, application for injunctions, applications for mareva, applications for arrest before judgment, orders of commission, all those things, striking out of suit, summary dismissal. Very, very interesting. It is just one template, just one template. We will develop that one template in the next class. We will develop it, and then once we develop it, we shall be using it as a template. We add, we remove, we add, we remove, and you will realize that it is going to be very easy for you. Now, as you do that, or let me take questions, and then I'll give directions in terms of what you need to do every 4 a.m. Questions, please. Anyone with a question? Ask questions. Yes, Saina George, we start with you.
Yes, thank you, Malimo. I appreciate that you have taken us through affidavit of service, especially paragraph 2 and 3, where the advocate is the one who is serving. Now, how about when a process server is making the service? How will
the same thing? The same thing. Just replace I'm an advocate of the High Court of Kenya and just say I'm a licensed court process server. That's that. The same thing. If you're the police officer, right there, I'm a police officer. So whoever is serving, or you can write I'm an advocate's clerk registered to serve. So again, the same thing, nothing will change. The same thing. Just say who you are. Anybody can swear an affidavit. Who you are. I'm an advocate of the High Court of Kenya, 1. I'm a licensed court process server, 2. I'm an advocate, a clerk, registered, duly approved to serve, or I'm a magistrate. Of course, you know that magistrates also do serve, or I'm a police officer appointed under this Police Service Act and duly licensed to serve. So just remove and add, remove, replace. Tuko sawa?
Sawa, thank you.
All right. Maswali. Guys, are we together? Everything is proper. Everything is clear. Please confirm by giving me a show of hands. Some people say, I want people to say, 5 people. 5 people to tell me, yes, everything is proper. Just unmute and say yes or no.
Question.
Everything is
Yes, mute your microphone. You don't speak until I tell you to. Who is that? Zema Yokitu. All right. So, guys, you guys you're giving me mixed feelings. Some are saying no, some are saying yes. Let's go to questions. I can see more hands. Yes, who are these people with hands? Can say okay. Kamunyu, let's go. 1. Next
Yes.
question.
Okay. On the affidavit of service,
And
number
please,
3.
before Kamunyu speaks, guys, this thing is very simple. As I'm speaking, as I'm discussing a concept, I'm assuming you have your pen. So anything that is not making sense, you write it down. Not that after I'm done long ago, that's when you're remembering a question. It doesn't work like that. I want you to be following with your notes. Anything that doesn't make sense for you, you can circle it or put a note there so that when I say, hey, who is having a question, you put up your hand and we save on time. Are we together? So that everybody moves faster. Kamunyu?
Yeah, I just wanted to assist maybe anybody who was following your drafting, where on number 3 you indicated that I proceeded to the defendant's advocate's office, XYZ Advocates LLP. Maybe you can write a BMX just in case someone was following exactly as you drafted. If I'm wrong, I stand guided.
What do you mean BMX?
The defendant's advocate, maybe BMX, Advocates LLP. Is that what you meant, maybe?
No, why BMX? I'm asking you why have you picked BMX as the advocate? BMX specifically.
Okay, because XYZ is a plaintiff and BMX is a defendant. And you are serving the defendant, right?
But BMX is the defendant. So if you're serving the defendant, BMX cannot be BMX advocate. BMX is the defendant, so BMX cannot be the advocate again.
Okay, where I served the said notice upon Mr. XYZ. Oh, okay.
So what I'm saying is you can replace let me just edit that. I know how some of you operate. Some of you are just specific to their details. So let me just read Mr. Josephat. Let me say Josephat there. And then let me remove XYZ. Let me have defendant's office, Wakili Advocates LLP. So the names will always change. So what I'm simply saying, how did you serve? When did you serve? And where did you serve? Who did you serve? That is exactly what you're saying. Okay. So I've already replaced that as Wakili. So BMX cannot be an advocate because BMX is our defendant. In the question, BMX is our defendant. So therefore BMX cannot be an advocate. So the defendant's advocate here is Wakili Advocates LLP, where you served Mr. Josephat. Are you together? Wow.
Yes.
Kamunyu.
Yes, I understood what you meant. However, I was looking out for some of my colleagues who will probably feel, otherwise. But yeah, it's very clear now. Thanks.
All right, and also remember that it applies both ways. The person that is serving can be the plaintiff or defendant's advocate. It depends. Who did you serve? You served. Who are you and who did you serve? Okay. I'm the plaintiff's advocate, or I'm this person, and I served this person. Okay. And give us the narration of what happened when you served. What happened? Did they accept it? Did they refuse it? Or if they stamped it? Okay. And then you give us evidence. You can attach a copy of the stamped one. So there. for reference. Okay, that is proper. That is proper. Now those 5 people, I need a quorum of 5. Unmute and tell me whether everything is clear. So I need 5. Just unmute.
Mwalimu, everything is clear.
Everything is clear. That is Benina.
Everything is clear, Mwalimu.
Nora.
Everything is clear.
That is Opande. 2 more. Two more, guys. Can you speak?
Everything is clear.
Lastly.
Everything is clear, sir.
All right, that chapter is closed. So let me give directions in terms of next class. So in the next class, we'll have the topic called interlocutory applications. Mute your microphone, please. No more questions now. In the next class, we'll have interlocutory applications. That is topic 7. But before topic 7, we'll have amendments of pleadings. Amendments of pleadings. Just wait first. Now, I want you to go, if you look at your course outline under topic 7, there are a few things that are listed there. The first thing that is listed there is the question of applications and the types of application. I will discuss that. You don't need to read anything on that. Now, we have applications under order 40. Okay, applications under order 40, which is the question to do with temporary injunctions. Read on temporary injunctions. Don't draft anything. Just read on temporary injunction. Jella versus Cashman Brown and the grounds for getting temporary injunctions. Read on test suits. That is order 38. Read on test suits. Read on the Anton Pillar and Mareva. That is under 39. Mareva under 39. Read on interpleaders. Read on, we already discussed third parties. Read on summary dismissal, summary dismissal, summary orders, application for summary orders under order 36. Read for striking out of pleadings, the 2 rule 15 should be, and then read on default judgment. Just read the content. Don't draft nothing. Don't draft anything. Just read. Have the content. Okay, read on the content, and then that content that you've read, we will put it in an application now. There's only one application that is applicable in all these, just one only. So the reason why I'm telling you to read so that you can know, number 1, the prayers, and you can know the grounds. Okay, mostly your reading will help you with the grounds. Okay, so just read on those things. Just read don't draft. You can draft if you have time. Again, you can practice drafting before that, but just read. If you read the content, when you come to class, we will prepare the first template, that is the application, and that application will apply in all these. In all these. So please read, and then we can come and talk about topic 7 in the next class. And then it will take us around 2 classes, I think, for amendment and topic 7, and then we can go straight into other things. All right. Final questions now. And guys, I've told you, please put your questions down. Have questions written down so that once we are done with questions. But if you guys are thinking on the go, it will not work. We will waste time and time. As you are proceeding, if I say something that is not making sense to you, note it down. The moment I stop, ask the question. I don't want to go back and forth. Mora Omwenga, tuko kwako.
Yes, you had promised to spare like 10 minutes. We go through our question.
Oh, sorry, time is up now. It's already 8:48. That is should be 10:48 your time. It's already time. We can start with it in the next class. So I didn't even realize that I'd promised that. Damn. So sorry. But I can't keep you guys here for long. Personally, I can. But it is not in the best interest of you guys to stay here for long. It's already 20 minutes past the time. We're supposed to stop at 10:30, but it's now all. So if we start reading that question, we'll end up leaving this class at 11:30. I don't think you guys are ready for that. So if you allow me, we can start with it the day after tomorrow. That is on Monday, first thing. Monday, we project that questions, we run through it quickly, and then we go to our discussion for the day, which is amendments and applications. If that applies, we can proceed. You sawa?
Yes, thank you.
All right. Somebody had another question. Can't see them now. Was it Saina, George, or someone? I don't know. Saw some hand up. All right then.
Yes, it was me. Thank you. My question was that
But why are you not
suppose
asking? Wait, why are you not asking the question? And I'm just trying to pick someone with a question.
I was trying to unmute my mic, but it took time to unmute.
All right, proceed, cancel, proceed, endelea ukili.
Yes, my question is now you also said that this is where an advocate is involved. What of where the parties are acting on their own? Can either of them just instruct the process server directly to make the service, or is the court to give directions?
No, if parties are acting on their own, parties who act on their own are allowed to serve. So you'll just write there, I, Saina George, okay, of PO Box do make oath as follows, that on this day, because you're acting on your own, it means you drafted it on your own. On this day, I drafted this, I proceeded to serve it. So just use your name. Just use your name. So you don't have to, but also you can instruct a process server to do the service for you, but the process server will be the one swearing the affidavit, not you. Okay? So the person that serves will be the one that is swearing the affidavit. So if the person that served is you, then you. Okay? If the person that served is a process server, then him. If the person that served is a licensed courier service, then that is them. So again, who served? The person that served is the one that's going to swear the affidavit. So you, as a person acting on your own without an advocate, you are allowed to put in your affidavit and serve. That is that. Another question? Somebody's holding a question. I can't remember the name. I think I saw some hand coming up and down. Lovely something. Lovely Joy. I don't know whether that was you. And I think I saw Wakiaga somewhere. You guys put your hand down and you're not asking questions. Okay. I assume we're fine. We're good?
Mwalimu, I only wanted to say that everything is okay at that time. Then when we reach the fifth person, I lowered my hand.
All right. That's fine then. Guys, again, please go and read everything we've discussed. It might look like it is simple now, but that is because your brain has been focusing on it for the last 2 hours. If you just leave it like that, you'll not remember. So just go and read again and consult, ask your friends, your group members. If you're a lone ranger, if you like reading alone, again, take time alone and read. Ask questions anytime, as many as you can, and read. Above all, focus on your health. Be well, eat, get some sleep, speak to your families, call your mom, call your dad. Life is not that serious. Everything will be fine. You will pass. People have passed before. They're not better than you in any way. You will pass. So take care of yourself. I will see you guys tomorrow for conveyancing as we introduce leases and sectional properties. All right, guys, the recording has been stopped. I will share the recording as I usually do.